We're not just actors.
We're not just trial consultants.
We've been cross-examined over 1,500 times in cross simulations to help train and coach some of the world's top trial attorneys.
Through live witness sparring, we'll test constructive cross techniques, share fresh insights, and explore new strategies.
And even though the testimony may be fake, the trial skills, totally real.
So let's experiment, discover what works, and have some fun in CrossLab. This show is brought to you by Trial House Consulting and powered by LawPods. Welcome to CrossLab. I'm Steve Hohman.
And I'm Olivia Espinosa.
Now, we have to be completely honest with you. We are not lawyers. And even though this is a law podcast, we're actually not going to talk about the law at all today.
Nope, we are actors. So we are going to focus on storytelling and how you make your witness and fact finder feel. We're going to focus on what we call a yes and cross.
Now, you probably know this as constructive cross. Well, our background is in theater and in improv. And what we discovered is the same skills and techniques used in constructive cross are the same things that we use in improv. And they're the same things that can help you get more admissions and do an amazing job of teaching the jury.
So we have designed a test case and invited 3 talented trial attorneys to spar with us as we play their witness so that you can be inspired on your next depo or trial. And other than what the lawyers have already prepared, none of the cross simulations are scripted. So this can be just as unpredictable and realistic as possible.
Let's introduce our guest trial lawyers and let's get started.
So first, I would love to introduce Susie Injijan. She is an award-winning trial attorney based out of Berkeley in the San Francisco Bay Area. She represents plaintiffs exclusively in personal injury and wrongful death cases. Welcome, Susie.
Thank you. Great to be here.
And we also have Russ Goodrow. Russ, he enjoys helping people find justice for their harms and losses and when they're been injured by someone else's carelessness. Thank you so much for being here, Russ.
You're welcome, Olivia.
And finally, last but not least, we have Jon Choate. Jon is a trial lawyer representing catastrophically injured people and their families in Alaska, California, New York, and Washington. He lives in Brooklyn, New York. Welcome, Jon.
Thanks. Thank you for having me.
Well, welcome, all 3 of you. We have worked with you in different capacities, so we're really excited to spar and have some fun with you today and discuss constructive cross-examination and depositions and anything else that comes up. One thing I do want to point out, so this is a plaintiff's case that we're working on today, and all 3 of you do plaintiff's work, but we always try to bring in a little bit of a wrinkle, somebody that's outside of that. And actually, Russ, you started out doing defense work before you started getting into plaintiff's work.
I did. It was criminal defense, not civil defense work, but I did that. That's how I was raised on those type of cross-examinations.
And so we always want to bring somebody in, and we're really excited that, and I did mean to say criminal defense because it does make a big difference. But it's always great to get somebody with an outsider's perspective, and you have both. You have your foot in both doors, so it'll be really exciting to see the difference, how each one of you approach the cross today. And that's where we see, like, we can all learn something. We all gain something. We all discover something when we see a little bit of a different perspective from everybody.
Yeah, and we'd love to ask real quick before we jump into our test case for today, when y'all are formulating a cross, is there a specific place that you start from that is sort of your guiding post as you continue? Susie, would you say you have a certain sort of starting place?
I think so. I start with, how do I want the jury or the fact finder to respond to this witness? What is the feeling I want to generate through this cross-examination when it's ended? And that really guides me in terms of how I break up my chapters and pursue the issues that I want to get through.
Mm-hmm. Would you say you're in the same kind of boat, Russ? How do you start typically?
Yeah, it is pretty similar for me, Olivia. It starts out big, and I try to get it smaller over time. And for me, the various trying to figure out the stories and then the chapters and the emotions within those chapters. So it's really going from very large to something small.
I assume the most difficult thing is knowing that you have such a huge and grand perspective of your case that the difficult thing would be to sort of whittle that down. What would you find, Jon, is the most difficult part to kind of getting all of that together in the final moments?
I mean, for me, it's always, especially when you're dealing with a medical expert who's, high paid, they have years of training. They've been doing this work sometimes for years, decades. I've testified in hundreds of cases. Whenever you find something where you're like, oh, I can show they got that wrong. It's really tempting to just, like a dog with a bone, go after that. But sometimes it's not actually something that is going to help your case with the jury or, leave, as Susie was saying, kind of contribute to the feeling you want to leave the jury with at the end of it. It's so much about the impression the jury has of the expert at the end of the day, as often as opposed to what specifically they said.
Yeah, I mean, when we've done a lot of this work that we're doing today, the simulations and doing mock trials and things like that, it's always interesting, especially the mock trials that we've done, where you get the feedback immediately from the mock jurors that they have watching the crosses and whatnot. And that sometimes if you beat somebody over and over again, they get really bored really, really quick. And so, when you say that, Jon, it just reminds me of those times where playing the expert witness, I'm like, okay, cool. I've got you tangled up. Let's stick with this. Go ahead and beat me up over that. Cause I know we're not moving forward with anything. So it's just interesting that I recognize what you're saying. And I've seen that, from an outsider's perspective with the work that we've done. We have a case today. We've got a case that we're going to be working on. It is a plaintiff's case, as we stated before, and it involves an expert witness. Let's go ahead and learn about our case.
So this is the case Sandra Little versus Grant School District and Gary Carpenter. Sandra Little, a 59-year-old administrative assistant, was injured when a school bus driven by Gary Carpenter collided with her parked SUV that was in front of her home as she was getting into her vehicle. The impact threw her onto her lawn, causing a mild traumatic brain injury, an MTBI, a herniated lumbar disc, and other injuries. While Sandra claims these injuries have affected her memory, mood, and ability to work, the defense argues her injuries were primarily soft tissue injuries. Any additional symptoms are due to pre-existing degenerative conditions and that there is no evidence of any lingering issues from her MTBI.
All right, so you're going to be crossing the expert radiologist for the defense, the expert witness radiologist for the defense. I will be playing Dr. Benjamin Williams. Your goal is to challenge their conclusions and bolster your client's case, Sandra Little.
So everyone is going to have 10 minutes. And if in the interest of time, if there is anything you would like to say that you've confirmed ahead of time or that you've sort of covered ahead of time, go ahead and let us know. And we can make sure to just keep that in mind as you jump into whatever line of questioning, whatever part of your chapters that you want to jump into. So Jon, you are going to be up first. Before we start, or anybody, do you all have any questions about the case itself and the brief today?
In terms of setting, we're in trial.
Yes, that's correct.
And okay, and we're in the defense part of the case. We're not in our part of the case. So there's been a direct ahead of us.
Yes.
Okay.
Yes.
I had a quick question about Sandra. In her medical history, has she ever had any prior complaints that are documented of memory loss or cognitive difficulties?
No.
Okay. That's all I need.
Good questions. I will say this, though. If you want to imagine, for the other two lawyers, if you want to imagine that there was just a deposition for the defense and you're bringing that expert in for a cross, if whatever you want to do, you just let us know. I don't know how exactly that'd work because I'm not a lawyer, but if that's a scenario that helps you out, it's all good. It's all gravy.
Jon, I'm going to give you 10 minutes and it'll start whenever you start. So whenever you are ready, the witness is yours.
Good afternoon, Dr. Williams.
Good afternoon.
Doctor, Am I correct that the lawyer for the school district who hired you provided you with some materials to review informing your opinions in this case?
That's correct.
And you've discussed some of the radiology imaging that you've reviewed, but you were also provided other materials about what happened in the crash itself. Is that fair to say?
I was given the police report as well as the the basic facts of the accident. But I will say what happened in the accident. Although I consider it doesn't really have a bearing on my findings.
All right. Well, I would like to ask you a little bit about some of those things that you were provided and maybe considered. And you were also provided the deposition of Miss Little, my client, right?
Yes, I'm sorry, I didn't mention that. Yes.
Okay. So let's go to the police. Let's talk a little bit about this crash and the information that was provided to you for your consideration and forming your opinions. So this occurred on August 23rd of 2022, about 7 a.m., right?
Yes, I believe so. Yes.
And there was a school bus being driven by Mr. Gary Carpenter, correct?
Yes, that sounds about right.
And I'm going to put up for you Plaintiff's Exhibit 1, which are photographs that you may recognize from police report. You see those?
Yes.
Okay. And you see this picture of the bus?
Yes.
That's a full-size school bus, wouldn't you say?
That is.
Probably about 25,000 pounds?
Correct. Well,
okay.
Actually, let me retract that. I don't have any expertise on the weight or size of the bus. All I can say is it looks like a standard school bus to me. I'm not an accident reconstructionist, so I don't have an expertise in that.
All right. And, no one's asking you to do an accident reconstruction here, but you don't have any reason to disagree with me if I represent that the weight of that school bus is probably about 25,000 pounds, would you?
I don't.
And you read in the police report, or you saw that the bus was going about 30 miles an hour when it ran into the back of Miss Little's SUV, correct?
Yeah, that sounds about right. Yes.
And the event data recorder on that bus showed that no brakes were applied before the collision.
Yes, that's in the police report. Yes.
Okay. And Miss Little, my client, was in the process of getting into her car at the moment that bus struck. That what you have in your file?
Yes, that's a description.
All right. So she was basically halfway in the vehicle, halfway out the vehicle. Sound right?
That sounds about right. Yes.
And I'm going to show you another photo from Plaintiff's 1 from the police report. And the impact from when that 25,000 pound bus collided with Miss Little's vehicle as she was getting into it, it crushed the rear left quarter of the SUV. You see that?
Yes, there was an impact there. Yes.
And it propelled that SUV 61 feet, correct?
I see that it did push her vehicle back onto her lawn.
By about 20 yards.
I couldn't say.
Well, I'm not asking you whether you measured it. I'm asking you whether you had information that conveyed to you that it was propelled about 61 feet. Is that accurate?
That's accurate. And
Miss Little was thrown in that same collision from the SUV. You'd agree?
I believe after the car stopped on her lawn, she fell out of the car. Yes.
And there was nothing other than her holding on to the steering wheel to keep her in that vehicle as it was launched 61 feet, correct?
You know, I couldn't say one way or the other. That's what's being represented to me in the materials I received. Looking at them right now again, but you know, any confirmation of this is, you know, not germane to my expertise. So, you know, I have my own opinions, but none of that is admissible.
And you've discussed your opinions with the council for the school district, but I'm right now, I'm going to ask you some questions about this information that was provided to you. Okay.
Sure.
After Miss Little was thrown from the vehicle, first responders came, correct?
I believe so.
And she was taken to the ER.
Yes.
She was treated for a head injury.
Yes, that's correct. As well
And
as
she,
the back pain, I believe at that time. And I think there was some a soft tissue injury to her shoulder as well. But I know that she complained of head and neck and back pain.
and shoulder pain too, correct?
Yes.
So immediately after this full-size school bus collides with the back of her SUV as she's getting into it, propels the SUV 61 feet, knocks her out of it. She's taken to the ER where she complains of pain to her head, neck, back, and shoulder. Correct?
That's correct.
And you were provided medical records for Miss Little going back a number of years before this crash, right?
I was provided, I believe they provided me with everything that was available from that. So it did go back slightly before the incident, but I don't have her whole medical history.
All right. Well, no one from the defense provided you with a medical record where there's any report that Miss Little suffered from any problems with her memory prior to this crash, correct?
Not that I'm aware of.
No one from the defense provided you with a record that indicated that or reported that Miss Little suffered from any cognitive issues prior to this crash, right?
Not that I'm aware of as well.
And you are aware from Miss Little's deposition that before this, she did yoga regularly, right?
That's correct.
She gardened.
Yes.
She went skiing during the season.
Yes.
And at age 59, she regularly ran marathons.
That's correct.
She also had 3 little grandkids that she loved to run around with, right?
I can't speak if she loved it, but I'm sure she did.
Now, after this crash, the medical records show that Miss Little complained of memory loss, correct?
She did.
She complained of cognitive difficulties.
Yes.
She complained about chronic back pain.
Yes.
She reported depression.
Yes.
She reported to her doctors that she was no longer doing yoga, right?
I believe so, yes.
She wasn't gardening as much.
I think that's in there as well, yes.
You saw in her deposition that she was unable to go skiing with her family.
I saw that she chose not to.
And she hasn't run a marathon since this crash.
No, she has not.
Doctor, you're being paid $800 an hour for your time here today by the lawyer for the school district, correct?
That is my rate.
And how many cases have you testified in as a paid witness?
I don't know the number specifically, but I believe it's about 800 in the 30 years that I've been doing this.
And am I correct in my estimate that about 95% of those cases you've testified for the defense in that case, as opposed to the plaintiff, people like Miss Little.
That's who's reached out to me. Yes.
Thank
I
you,
would be
Dr.
happy.
Williams.
That's
I'll pass the
exactly
witness.
10 minutes. Look at you. Jon, how did that feel? Did you accomplish what you wanted to accomplish, what you set out to do?
I got through the material that I wanted. I didn't get the presentation wasn't necessarily how I wanted to do it. This was going to be ideally my courtroom. This would be on butcher paper, on a pad, writing down each of these things. Full-size school bus.
Yes.
You know, if I get 25,000 pounds out, I'll get the 25,000 pounds. 30 miles an hour, no brakes. All with an expert like this, who's a pro. 800 cases. I am not going to put a dent in this person. I'm not going to trip them up unless there's some grave error. But what I can do is I can use them to emphasize the facts that are undeniably powerful for my case, especially one like this, where candidly, it's a the facts speak for themselves. But ideally, I would have had that out there, and then I would have had a stronger ending. But I kind of without my visual aid, I sort of lost my momentum a little bit.
Oh, interesting. Because I was actually, honestly, you didn't have that checklist, but I could very well see it in my head, especially because of just the way that you were sort of filleting it out for us. In particular, when you said she had no memory issues, no cognitive, you were kind of just bullet pointing, and then went back to it later and added she didn't have chronic pain, she didn't have depression. So even though you didn't have that, I'm going through that checklist in my head. I could definitely see it. You also painted a really great picture of her beforehand, yoga, gardening, even adding in 3 grandkids at the end, which is just a wonderful picture of who your client is and obviously what has happened to her since. I wrote down all of your fantastic word choice too. In addition to coming back to the 25,000 pounds, crushed, propelled, launched, just really things that ignite an imagination. How did that feel to you, Steve?
I was going to say that I was about to start getting more admissions in there, or volunteering more information, because you were in complete control that whole time, and I did not like that from my vantage point. And I tried to fight you on certain words where you said launch and I said fell, and pushed, and you said, I can't remember the word you used, but it was a much more violent word. But you didn't get into it with me. And I was hoping you'd scrum with me a little bit on some of these words, but you're very disciplined. And it just shows that when you're using those constructive cross techniques, leading questions only, one fact at a time, and going from that general place to specific, it's really hard. You have to be really good, a really good witness to fight through that and to find the points. And I was really chomping at the bit to do that, but we ran out of time, but it was very effective. Very frustrating for me.
I want to add in another one Steve tried to kind of, take you off track with. You said something like, she could not go skiing. And Steve said she chose not to go skiing, which you did not bite on, which is great. In fact, you were so in control, Jon. At the very beginning, I even noted this. It was very easy to listen to, but you said it was a full-size school bus, 25,000 pounds. Steve first said yes. And then he realized, oh God, I'm just agreeing a lot. And he tried to backtrack on it. But it's just because it was such an easy sort of in control conversation that Steve didn't realize that you were pinpointing him right away, right off the bat there.
Yeah.
Yeah.
Yeah. I mean, that was also a bit of a trap because the first thing I always do if it's a fact that I don't have an evidence somewhere, but I think it's something that someone should agree to, is I Google it. And I look at the first Google responses for the question, because I know that, although jurors shouldn't do this, some member of the jury is going to Google that question. And if the expert doesn't agree with, because 25,000 pounds that's also sounds about right to me. So if the expert goes, no, it's 7,000 pounds, I don't need to fight with them about that.
Mm-hmm. Yep, absolutely. I want to go to Susie and Russ. I would love to hear what you found effective, what stood out to y'all. Susie, if you want to go first.
Sure. Yeah. I thought Jon did a fantastic job with one of these hard to crack nut experts because, you know, and Steve did exactly what this type of expert would do, you know, basically saying, yeah, I know about all these facts of the violence of the impact and how anybody's going to who understands and accepts those facts is going to think, yeah, this is injury causing. And I can imagine that it did cause her injuries. And so Jon was very good at just pummeling him with those very vivid facts of the incident so that the jury is there seeing it happen. And you're watching this expert almost disregard the import of these facts. And that just chips away at his credibility. So it's effective without needing any concessions from him at all. Because, yeah, he's conceding, but he's conceding in that way like, well, yeah, I know that, but that doesn't change my opinion. But the more you get him to do that over and over and over, the more I think the jury sees how illogical that is and how, purchased his testimony is.
Mm-hmm. A little bit cocky there too, right? And at the $800 an hour rate. Yes. Russ, what did you find was effective? What stood out to you?
Yes, Olivia, thank you. Jon, I really enjoyed this. I didn't think of this area of inquiry, and it's so fascinating to me about what you did, because you focused the questioning on the defendant's behavior and switching from criminal to doing civil plaintiff's work. One of my mentors is Lee Johnson, and she's described this and pounded it in my head by using the movie Tombstone as an example. And in that movie, it begins, the first scene is the married couple comes out of the church, and the priest and the kids are running around, and the villains are there in the town square, and they shoot it all up. And it brought me to that, how powerful it is when we, as plaintiffs' lawyers, remind the jury why we're here in court. And that the car flew 61 feet. I don't even remember registering that as I went through this, because in my mind, that fact's not about a neurologist. So I really appreciated watching this.
Mm-hmm. Have you, I'm assuming y'all have faced an expert like this before. Susie, it sounded like you have. What sort of, when you think about an expert like this, what tactics do you typically use or in your sort of toolbox with this that we haven't covered?
Well, I actually, you'll see what I did, because I took a different approach. I assumed that a neuroradiologist oftentimes isn't even given the plaintiff's deposition, because their attitude is, I'm just looking at the evidence, and the only evidence that's relevant to him and within his specialty is the diagnostic imaging. And so they will purposefully not give these facts to the radiologist. So I would basically hold him to that. So, and basically try to establish that all you know is what's in this scan. You don't know all this other information that we know. And so you cannot diagnose the person. You can read a scan, but you cannot diagnose the person. And so, we have here in the San Francisco Bay Area a very formidable expert radiologist. I'm not sure he's a neuroradiologist, but he's used in a lot of the auto cases, and he is extremely slick and difficult to cross-examine. But I find that that's kind of a good thing to do, because he's such a specialist. You want to hold him to that. You want to limit his expert testimony to that.
I think it's a good time where we take our first break, actually the only break we're going to take today. So we're going to take a quick break. And then when we get back, we're going to have Russ going and taking a stab at this expert witness. Since we're taking a break, let's quickly talk about our partners at Law Pods. a lot of people think that that's the company that just produces the podcast for TLU or Trial Lawyer Nation, but actually what they mostly do is work with lawyers just like you to reach non-lawyers, aka potential clients.
Yeah, podcasts let your audience get to know and trust you. And Robert Ingalls and his team make podcasting easy.
With over 100 million people expected to listen to podcasts this year, there's never been a more effective way to market your practice.
To get more information, visit lawpods.com. That's LAWPODS.com. Tell them we sent you.
Well, welcome back. We have our next cross-examination. I will be going and sparring against Russ. So that is, that's our next cross.
Russ, do you have any questions before we start, or anything that you want us to know that you covered with this witness before you jump in?
No, not that I can think of right now. Afterwards, I might, but not now.
Sounds good. So you have 10 minutes. I'm going to start whenever you start, but we're going to jump off camera just so that you can focus on Steve and, well, excuse me, the doctor, whenever you're ready.
Thanks. Dr. Williams, you read all of Miss Little's medical records?
I reviewed everything that was given to me, that was provided.
All of her x-rays?
Yes.
All of her MRIs?
Correct.
So you reviewed all of Miss Little's medical records, x-rays, and the MRIs?
Yes.
Hundreds of pages?
There was quite a bit. I couldn't tell you exactly how many pages, but it sounds about right.
Was it thousands of pages?
I couldn't say. It was several hours worth of work.
How long did it take you?
I believe it took me 5 hours to review everything and make my, about 5-6 hours to make my findings as well.
In your 5 to 6 hours to make your findings, you identified something that you called a stable chip fracture in Miss Little's neck.
And that was actually not in her medical records. I discovered that in the MRIs and actually the X-ray as well. So that was something that was missed.
So you found something that that Miss Little's treating physicians missed.
That's correct.
And when you found that, you included that in your report.
I base my reports and my findings completely on what is on the film. And so if there's something in there, if there's an injury there that is not listed, I absolutely will include that. It's black and white. It's what's on what the evidence shows me is what I am going to report.
You want to report what the evidence shows you?
Correct.
And when you're reporting what the evidence shows you, you're trying to be fair.
I'm not trying to be fair. I am being fair. It's what's on the film is what I see, and I'm going to call balls and strikes just like that.
You're going to call balls and strikes because it's important for you to be seen as a credible expert. Is that right?
Well, it's just the ethical thing to do. So it's what I'm going to do every single time.
Every single time, excuse me, you want to be seen, or do you see yourself when you work on these cases as like a fact checker?
I don't understand the question.
Do you see yourself in this role as reviewing all the medical records, reviewing the x-rays and MRIs, and double checking their accuracy?
I will, I am not checking for their accuracy. That's not what I'm being asked to do. I'm just asked to look at the the evidence and report what I find. So regardless of what the previous physicians have reported, that's I'm not trying to correct the findings that they had. I'm just trying to show or report on what I see. So as far as being some kind of fact checker or some, doubling back and trying to override their findings, it's not something that is an intention or something I'm doing at all.
You're not worried about the accuracy of the prior reports. Your goal is to be objective.
No, I assume that they are accurate. That's why I'm relying on the radiologist that took the film. I am considering the other medical records, but paramount to me is what's on the film. So that's, but I'm not second guessing the treatment or the treating doctors are there to treat. It's a different thing than what I'm doing. I'm reviewing for causation or see what would likely be caused by this accident.
It's paramount for you what you find on the films.
Absolutely.
And the films in this case that you saw, there was no before the crash, no films showing that Miss Little had a neck injury.
Well, she had never gone for or reported a neck injury, but if she's reporting that at age 59 that she had a pristine neck and back and any other part of her body, I would I'd find that hard to believe, especially how active she is as far as marathon running and gardening. That's a lot of hunched over. Likely she had, not likely. These are all degenerative conditions that she had up and down her spine, apart from the edema that she had from the accident, the soft tissue injuries. But osteophytes are caused over time. They're not something that happens in a short amount of time.
You saw no imaging before this crash that Miss Little had a neck injury.
I saw no imaging one way or the other, so I can't speak on that.
Doctor, you saw no imaging of Miss Little's neck before this crash that showed an injury.
I saw no imaging from before this crash.
You saw no imaging of Miss Little before this crash of an injured back.
I saw no imaging of her back before this injury.
You also saw no imaging of Miss Little before this collision that showed memory loss.
That's a loaded question, just because that the imaging that was provided to prove that that is not a proven source. It's something that is very hard to replicate, and I don't have any other records besides the tensor, the DTI that was taken. There's no other records that show, or any other imaging that helps back that DTI up, and it's a highly experimental imaging. So no, I saw no other imaging because this is not something that's widely accepted.
DTI is highly problematic. Before the crash, did you see any x-rays or MRIs that showed Miss Little had memory loss before the collision?
I saw no imaging of her brain or anything like that.
You would expect, doctor, to see in the medical records neck pain, lower back pain, and memory loss before the crash if those were symptoms that Miss Little suffered before the crash.
I can't speak on the memory loss. Sometimes if somebody's having those symptoms, that's something that might not get reported for some time. They might not even realize that they're having memory issues. As far as the neck and back, when you have the types of degenerative issues that she had up and down her neck and back that happen over time, it's much like that analogy of a frog in boiling water. Well, the frog doesn't realize they're in pain until it's too late. Well, it's the same kind of thing. You don't realize your injury until there's that inflammation there, and the soft tissue is pushing up against those osteophytes, and then there's pain. And then they discover that those degenerative issues were there, but they might have not been aware of that before.
Thank you. Miss Little never reported neck pain, lower back pain, or memory loss before the collision.
I don't have records of that, no.
You don't have records of that, and you don't have any x-rays of that.
I don't.
You don't have any records of that. You don't have any x-rays of that. You don't have any MRIs of that.
I don't have any imaging of before the accident.
You did, however, see MRI images of Miss Little's lower back after the collision.
I did.
In the MRI images of Miss Little's lower back after the collision, you saw something you described as degenerative narrowing.
Yes.
And you also noted that you saw arthritic changes.
That's correct.
I'm going to stop you there. Nice work. All right. Russ, I'm going to start with you. How did that feel? Did you feel like you accomplished what you set out to do?
10 minutes is so fast. And so I really, Steve, can we just work until midnight on this? I have pages for you, man. Olivia, I feel okay about getting what I wanted to accomplish. I'm trying to learn how to be more friendly or constructive, dynamic, I think is what McComas would call it, with the witnesses. And so it feels new word, not right. I don't feel like I chopped off Steve's head.
Oh, interesting. I think I might disagree. I will definitely go to Susie and Jon for their opinion, but I do have to, first of all, I'm just going to give you extra points right off the bat for using a trilogy to start. You reviewed all the medical records, all the x-rays, all the MRIs, and then you did a little summary there, and then you brought it back at the end. So we reviewed it once again. But that is just such a clear thing in our head already, and that you came back to multiple times. He did not see anything before the crash, before the collision. You did a great job of looping, which I think is also just makes it so conversational that you might not realize on the inside how it feels, but as a listener, when you're looping and looping our words as a witness, it makes us feel heard. I know you've heard this before, but just for those who haven't, as a witness, it makes us feel heard and it keeps us in control. But as a listener, it's just really easy to listen to and it's conversational. So I wouldn't say that you are not friendly and that you need to work on it. It's just very much, that's what we're getting as we're listening to you. And even just sort of the idea that you were asking very pointed questions and Steve was going off and you just repeated the question again and a little bit shorter the second time. He went off and you just tried to just sort of incrementally stick him to it. But again, in just a very conversational way that felt easy, even though I felt that you were in control. He went off on you a lot, but you stayed the course. Yeah, Steve, how did that feel?
And every time I went off, you looped something I said and then brought it back to confirm, like Olivia just said. Like you were looping to pull me back to your question, like almost every single time that I went off on a tangent. And that when that happens, from my perspective as like playing this expert, it is really like irritating. I hate it. I hate like getting pulled back by my own words, but there's really nothing to fight you on. It's just like, okay, fine, we'll move on. I'll throw in my little twist at the end of, well, that's all I saw. That's all I was provided, or whatever my little quip is, and move on. But you've got your admission, and you've got what you wanted, and now we're moving on. And I didn't really get, knock you off or tangle you up at all as well. You're still marching forward.
I also, before I move on to Susie and Jon, you're just always so good at using your body, your hands as a physical demonstrative. I know it was something really, really quick, but you said neck injury, and you're kind of pointing in whatever area that might have been on her potentially. But it's just a quick, easy thing as a listener to also sort of ground what you're talking about and, reconnect to sort of what is actually happening medically with her. Jon, what do you think Russ accomplished here? What was effective?
I really enjoyed your tone and demeanor. There was a sort of a groundedness to your questions. And the more Steve was trying to wriggle out and add stuff, and then you kind of returned back to, you used the loop, and then you came back to your question, it felt like something smashing up against like a strong tree. And he's like wriggling, trying to get out, and he keeps coming back to you, and you are just immovable. And it creates a sense of strength. And even though, I don't think you got in terms of what the factually all the way to where I think you were going to go. I could see where you're heading. Just him fighting you so hard while you were kind of immovable, it made him feel untrustworthy. It made him feel, why is he fighting so much before you'd even got to, your sort of the real meat of where you're gonna hit him. So you didn't need to chop his head off. I think you would have gotten there eventually with another 10 minutes. He sort of was just sticking his neck out by the end, kind of waiting for it to happen.
Yeah. In fact, I even just to add on to what Jon was saying, I could feel, because you started with hundreds of pages, thousands of pages. How long did it take you? 5 or 6 hours? I could see that coming back to, you get paid $800 an hour, right? Just stuff that you're already sort of setting up in terms of his amount of time and how much he gets paid. Susie, what did you find that he accomplished and that was effective?
So everything that I've heard is exactly what I was thinking. I was really impressed with how much Russ was looping. I mean, he really was present. He was listening, and he was looping a lot. And I really like what Jon just said, because I think it's very perceptive. I've been thinking a lot about this lately, about experts who protest too much. They put on the gloves, or they take off the gloves, however you want to look at it, and they're ready. They get in the ring with you. And when you're being the yes and kind of cross-examiner, like you're being, Russ, where you're just trying to draw out of him what constructively helps your case, he's fighting you. He's, throwing punches. It's like, why are you doing that? And I agree with Jon that hurts his credibility, because it makes him look like he's expecting you to beat up on him, and you're not doing that at all. So great example when, you bring to his attention the fact that he caught something on the scan that the plaintiff's treating physician didn't catch. And so you said quite naturally, so you see your role here as a fact checker. I mean, I thought that was brilliant, because that helps the jury also see, okay, so what is his role here? Okay, so he's going to be here to sort of as a counterpoint to the treaters, right? And what does he do? He fights you. He says, no, I'm not a fight chick. That's not what I am. And and so I thought you really scored a point there by, sort of like going along with him, yes-anding him, and then he's fighting, and he just looks like a buffoon.
I think that was one of your most effective loops, was you found something that the other treating doctors did not. That was really fantastic.
That was what got my chest pumped up, and I'm like, oh yeah, that's right. I found something they didn't. So that was great to start out that way, Russ, and kind of lead into the fact checking thing with that. That was really nice. I like that.
Russ, what goes through your head when like he's going off on you and you're looping so well? Like what are you when the witness is sort of going off like that, what sort of helps you pinpoint what you're going to take next? Is it just in the moment? What's your process there?
Yeah, that's a good question. It's really in the moment what sticks. And my experience when I loop, it seems to work, but in that I can move the witness off that confusing sort of rambling response. But with Steve, it wasn't working. And so I was trying to be patient, trying to be grounded, feel the floor under my feet, feel the weight of my body in my chair, and just remain present and patient.
Well, we have one more cross. Susie, you are up next. Thank you all for your feedback. That was a really great conversation. Susie, do you have any questions or anything like that before we start, or any admissions that you want covered before you begin?
No, I would just say that I am imagining that I'm getting up to cross after the direct examination of this defense expert. And this defense expert has not been given a lot of litigation materials, including depositions and so forth.
Understood. Okay.
Yeah. Perfect.
Fantastic. I will start whenever you're ready. So the witness is yours.
Thank you. Good afternoon, Dr. Williams.
Good afternoon.
You're a specialist in diagnostic neuroradiology.
That's correct.
And that means you're skilled at reading images of the spine.
Correct.
So you're skilled at reading X-rays and MRIs and CT scans of the spine.
Correct.
And you do this for your patients.
Yes.
You also read scans for lawyers.
I do. By and large, though, my day-to-day practice is working with patients, but it is something that I do as well. I've been willing to do for the last about 30 years.
For the last 30 years, and over that period of time, you've been willing to do that for about 800 cases. Is that true?
That's correct.
And when you read scans for patients, you're acting as a treating physician, right?
Yes, that's correct.
One of your patient's treating physicians.
Yes. Now, when I am working with a patient, I'm reporting all of my findings to their treating doctor. So the treating doctor is going to be the person that makes those decisions about what steps are taken, what kind of treatment is taken to resolve whatever those issues are. But that's my role in it, is to help give some light or some a view to that treating doctor of what is actually happening in those images.
Right. So you are one of a team of treating physicians with the patients whose scans you read and interpret.
That's correct.
When you read scans for attorneys, you are not acting as a treating physician.
No, I'm not.
When you read scans for attorneys, you are not being paid as a treating physician.
I'm not, but I will say that, and in this case specifically too, if I see something, I am going to report it just like if this was a patient that I was treating, and so they can take that to their own physicians, where, as you know, I was able to reveal that there was a small bone chip, and obviously there's no treatment that's needed for that. It heals on its own. But there was one time where I did, in doing this work, I did see evidence of cancer, and I reported that, and that helped out that patient as well. So if I see something, I'm going to report it, even though that's not necessarily my role.
So if you see something, even though you're being paid by attorneys, you're going to treat the patient whose scan you're looking at as a patient of yours?
I will do as I would with a patient I was treating. Obviously, I'm not treating them, but I will reveal all my findings so they can seek the treatment that they need.
Well, in the 800 or so cases that you've testified in over the last 40 years, you were paid by a defense lawyer to testify in 95% of those cases.
That's correct.
And in 95% of the cases in which you testified, you were not acting as a treating physician, were you?
No, and to be fair, it's 95% of the time I've worked for defense, but I've never sought out any of that work. It's all come to me. And I have worked with claimants before as well, and would gladly work with anybody that reached out. Either way, I'm going to reveal what I find on the records.
And in this case, Ms. Little did not come to you for an opinion, did she?
No, she did not.
And in this case, you're being paid by the attorneys for the opposing party, for the defendant.
That's correct.
Let's talk about your assignment, Doctor. When defendant's attorneys retained you, they gave you an assignment.
There's a service that I provide. So when I hear assignment, to me, it sounds like they're asking me to come to some kind of conclusion. The service I provide, which is something that I tell them what I do, is review the medical records, specifically the imaging, and report what I find on that imaging. So beyond that, there is no other assignment.
Well, your assignment in this case was to view Ms. Little's neck and back scans. True?
Correct.
And to report on your reading of those scans.
Correct.
As part of your assignment, you weren't given any clinical notes by Ms. Little's treating physicians.
I was not.
You did not ask to see any clinical notes.
For the service that I provide, that is beyond what would be helpful for me to reveal my findings, because it's either on the imaging or it's not.
Right. So you just read the imaging.
Correct.
And you were not provided a transcript of Ms. Little's deposition.
I was not.
You didn't ask to see a transcript of her deposition.
I did not.
And you didn't ask to see a transcript of the depositions of any of her treating physicians.
That's correct.
Or her husband.
Correct.
So you didn't see any information regarding the symptoms that she's been experiencing since the collision that is the basis of this lawsuit.
Well, I did not, but symptoms are, something that a treating physician is going to be very interested in, because they're going to be treating those symptoms. That's their job. Where what I'm doing, and what I do anytime I'm looking at imaging, is I'm only looking to see what is there. So if there's an injury there, that is going to be helpful to the treating physician. If there's not an injury there, or there's a different set of circumstances that are happening with their physical condition, that's going to be helpful to that treating physician too, to help treat those symptoms. So for me, the symptoms being reported, there could be a number of reasons for that. That's beyond what I'm ever assigned to do or ever asked to do.
Right. That's beyond what you're ever asked to do, whether you're being paid by attorneys or you're actually treating a patient.
Correct.
True?
Correct.
You never asked to see anything other than the imaging studies.
That's correct.
You've never met Ms. Little. Is that right?
I have not. To be fair, I have not met a number of the large majority of my patients. Most of the time, the imaging is sent to me. I review it, and then even nowadays, after the pandemic, most of this is done virtually too, and that way we can get results back to the treating physician much quicker. But to be fair, I don't often meet with most of the patients I'm working with.
Right. And you don't diagnose these patients either, do you?
I do not.
You would agree that a patient's diagnosis is based not just on the scans, but on other diagnostic testing as well.
It can be, yes.
It's based on the patient's clinical exam.
Yes.
It's based on medical history.
Yes.
It's based on symptoms reported by the patient.
Yes.
And it's based on other tests that are performed by doctors other than the radiologist.
Correct.
So when you read a scan and you're interpreting a scan, that's all you're reading, right?
Well, yes. And I will say that when there is symptoms of, like, say, pain, well, that's not something that we might not see the causation of that in that X-ray. We can see what it's not. And that's a lot of the time of what I am doing, is showing where that is not coming from. Or we can see direct evidence of that in the imaging. But a lot of the time it's, especially in these cases, we're seeing the evidence is there on the imaging. It's either there or it's not. I'm not making any judgment or any comment at all about the symptoms that these patients are feeling. It's just either there or not.
All right, that is time. Our long-winded expert going off. All right, welcome back, everybody. Susie, we're going to start with you. How did that feel? Did you accomplish what you started to do or set out to do, since we only have 10 minutes?
Yeah, so I'm going to echo Russ and Jon and say that I was only getting started, and I would have gone a lot longer. Yeah, I mean, I think, how did it feel to me? I felt maybe like I was very focused on making the point that I wanted to make. Maybe I stayed there a little too long, but he was giving me what I wanted, so I was kind of letting it sink in. And I was also really pursuing this as I would be in front of a jury, so that the jury is actually able to follow along without having a lot of background information or medical knowledge. So, yeah, it felt okay. It felt quick. It felt like just a start.
Yeah, that's my biggest note, Susie, is that I feel like you were my guide from the very beginning. The first question you asked him was, you're a diagnostic neuroradiologist, and instantly you defined it. And that for me is like, okay, she's going to let me in on all this information that either I don't know or is just over my head, whatever that might be. You did it. Also, he's got this long-winded answer about, I can't even remember what it was about how many people are looking through this. And then you boiled it down to, you summarized it. So you are part of a team. He had this long thing about all these people who are looking at it. And so for me, it's like that you're instantly telling me as a listener, oh, I don't have to listen to a damn thing he says. If he's going off, you're going to help clue me in. When he's done, I'm going to just have to listen to Susie, and she's going to fill me in on anything that I might need to hear. So instantly, I already feel like you're a guide, and I would rather listen to you because you're just going to summer it up quick rather than the doctor over here. And the guidepost that you have of, okay, now let's talk about your assignment, doctor. Again, just another great thing. Just shows me all I have to do is listen to you, and I'm going to get my story there. Yeah. How did that feel to you, Steve?
Yeah. Well, I was going to say every time you did that too, it wasn't inaccurate or coming to any kind of conclusions. It was all factual. Everything that you did would like summarize in fact. And so there was nothing else to do from my end. So I was able to talk, but every time you did exactly what Olivia just said right now, it was like, I'm getting some of the stuff I want to get in, but it's not getting to where I would want it to go. You were very much in control the whole time. And that's frustrating for what I'm trying to do. So well done.
Yeah, and even the sort of there wasn't any opinion, but you looped what he said in terms of treating them as a patient if he finds something. And you found that to be interesting, I think, because of your tone. You just looped it. You're going to treat them as a patient of yours. And it's not anything unlike he said, but because of your tone, and it wasn't offensive in any way, but it alerts me to like, oh, okay, that's odd. That's not normal for a guy like him to do. So you're inserting it in just the right way so that it's not anything that alerts your witness, but that we're cluing into as a listener.
Well, when she pointed that out, though, I had to walk that back because it's not my
Yeah.
role. I could never
Yeah.
say it was my role, and that would make me an absolute kook if I said I was treating them exactly like a patient. So that put me on the spot. That was a kind of a little stun that she caught me on. But I'm going to say this, and Susie, you're so good at this too, and everybody's shown this today. The super weapon, I think, with any cross or any of the work that y'all do is curiosity. That's such an important part. And that just showed right there, you know, Susie, you're always so curious. And I think that is what helps you find those little, you know, we call it, because we come from theater and improv and stuff. It's like finding the strange, finding that little thing that's a little odd and digging at it. And you could usually find something that's really good when you do that.
Yeah. Jon and Russ. Russ, we'll start with you. What did you feel was accomplished here? What was effective?
Yeah, thank you, Olivia. So we've been talking about spontaneous looping. Susie, I really liked your loops that it seemed to me that you had written down or in your questions. Acting as their treating physician, like Olivia said, part of a team of treating physicians, not being paid as a treating physician. So that treating physician and being a plaintiff's lawyer, I kind of see you setting up that comparison in advance. And so that was effective for me. I loved the word choice of your assignment. Your assignment. You know, this isn't about Miss Little. This is just your assignment. And then we've been talking about tone. And so when you say that you were playing as though you're in front of the jury, this makes sense to me because it was 95% of those cases. And you didn't go down a lot, but it just went down a little bit to just a subtle eye roll is how it landed on me. So I appreciated that.
I will confirm that I did not like that word assignment at all. So as you noticed, I thought I had to throw something back at you. I did not like that. So well done.
Jon.
Susie, I thought you were supremely comfortable. It didn't feel like you needed a warm up, as you started across. It just felt like you were 100% comfortable with asking this expert and crossing this expert, which as a listener just made me kind of put me at ease. I wasn't, I just going, oh, okay, she knows what she's doing. And that was great. I think that, in the 10 minutes you actually got him to a really great point, which was he was sort of almost, and it felt almost organic, spontaneous. He was basically sort of volunteering that, there's clinical diagnosis. There's all these other tools that doctors use beyond radiology, and he can just speak to that one little narrow slice. And they're all other sorts of things that might be playing. And you built that so well with your questions about tests other than imaging. I knew exactly where you're going to go with it. And I think the jury would have been able to and I think it would have been fun for the jury because I think it's always the most fun for the jurors where they can figure out where things are going too. And I feel like, like they're watching a mystery, and I think that would have been enjoyable for them as well.
One thing I would love to hear what you all think, but each of you said 800, and then each of you said 95%. I personally would have loved to hear. So in 760, cases. That was just in my brain. I wanted the extra sort of add up for me because repeating 760 as opposed to 95% seems bigger to me. I don't know in my head, but I would love to hear anybody's thoughts on that.
It was in my notes and I ended up not using it.
Okay.
It was just a game time decision, but I thought the same thing. And I brought it up earlier than I intended to because of where Steve was going. And he started talking about his experience testifying. And so I said, okay, let's talk about that. He said, I only do this some of the time, I'm also willing to do it. I'm like, oh, you're willing to do it in the last 40 years. It's been 800 times you've been willing to do it. And so then I went back to it, it seems superfluous to do the 760, but I was prepared to do that. And I would have done that had there not been that change in chronology.
Got it. Yes. Adjusting to what he gave you.
Yeah.
Yes, absolutely.
Nice.
So if you all had to cross this witness tomorrow, what's something you would take away from today? It could be word choice, tone, anything like that you might have picked up today from your fellow colleagues.
Yeah, I can go. For me, I really enjoyed asking how Jon asked the witness about the crash itself. There were really good facts. 61 feet, 20 yards, smashed in SUV, full-size bus.
And I would have loved to see that if we had more time to see that done where like in Susie and Russ's, I didn't have that information. So it was new for me. That would be a really fun experience to have. Well, fun in the sense, but probably not fun for my expert witness to say, I was not aware. But that would be, I would love to see that side of it too, if it would have went that way. I agree. That was really well done.
Yeah, I'm breaking it down, 61 feet, and you were prepared, Jon, with 20 yards. So doing it in different sort of increments. Yeah. Yeah.
I had a football analogy too, if necessary.
Yeah.
Two first downs, which, pretty
Love
significant.
Yes.
But if I could do it again, I would definitely do more looping. I would, there are some easy trilogies there, which I did not use, especially with the, bus 61 feet, and, crushed SUV. And I think also, I think some more visual language, like you guys recommended, doing more in terms of, I could talk a little bit more about the bus, right? A big old yellow school bus with, smell of the big diesel engine in front, and some other things to really help bring that, to make that more tangible for the jury, which.
Susie, how about you? Any takeaways or what you would do here?
So I think what I liked from Jon's and Russ's and from Steve's performance is how, just very softball questioning where you're recreating imagery of the actual collision with this expert, and his sort of blasé, I don't care reaction to all of it is very, very powerful, because that's what leaves the jury with the impression that he doesn't care about anything, and he doesn't care about Miss Little. And whether or not you even see him as particularly, polemical, you get the impression that he doesn't have a lot to add to this for the fact finder. I mean, what is he really telling us that we can use here to help us evaluate this case? And it just makes him look bad and uninterested and uninteresting. Mm-hmm. So I think that's something that I would more deliberately try to elicit in a cross-examination, because it's coming from him and less from me,
Mm-hmm.
Right. Absolutely. Yeah.
I love that. Well, we're at that point where we're wrapping up, but this is one thing I do want to try out for the first few episodes. It's something that we used to do in improv where we would say our favorite things at the end. And so we'll do, I want to point out and Olivia, you can add one in as well. But these are my three favorite things from today. The word assignment, I love that from Susie. I love the measurements from Jon, and the trilogy from Russ. Those are my three favorite things. Anything to add, Olivia, or anybody else, your favorite things from today's episode?
I would say Russ actually had 2 trilogies, potentially, maybe even more.
Yeah.
I like the idea of just the number of hours that you have worked on this, 5 to 6, in relation to how much you get paid. I think Jon also mentioned how much you get paid.
Mm-hmm.
And I would also say, even from Susie's, just feeling like I could sit back and listen, and I don't have to worry about even taking notes in my head, mental notes. She's going to catch me up. And as a listener and being on a jury, I'm sure that would feel really just a lot more just guided is really what it is. So I appreciate that.
Yeah, you guys did an amazing job, and we're so lucky to have you on this episode. I do want to mention, for everybody that's listening, all our trial lawyers out there that are listening, if you're interested in being in this, on the show, being a guest on the show, or if you just have an interesting case that you'd like to see as a version of it, as our mock trial case of the day, reach out to us. There'll be instructions in the notes below. Other than that, thank you, all three of you, for being guests today, and more importantly, for all the work that you do to represent your clients. We love it. We love being a part of getting you guys ready, because we know that you care so much. So thank you all so much.
Yeah, they're lucky to have you.
All right. Well, until next time, thank you all for listening.
Please like and subscribe to CrossLab wherever you get your podcasts or webcasts. If you really liked this podcast, please write a review. If you didn't like this podcast, this has been Paul Hollywood's Baker's Podcast. Thank you for listening to CrossLab, a Trial House Consulting production powered by LawPods. To get free resources for your next trial, go to houseimprov.com, HAUS improv.com.
The discussions and content presented in this podcast are for educational and informational purposes only. They are not a substitute for professional legal advice, guidance, or representation. Participation in this podcast, including cross-examinations and feedback, takes place in a simulated training environment with fictional witnesses and scenarios. Any resemblance to real persons, cases, or events is purely coincidental. The views expressed by the hosts and guests are their own and do not necessarily reflect the opinions of any organization or entities they may be affiliated with. House Team Productions and LawPods are not responsible for the accuracy, outcomes, or application of any content or strategies discussed during the podcast. If you have any specific legal questions or concerns, we encourage you to consult with a licensed attorney in your jurisdiction.